All right. And that was from a RPR literary section. Okay. We also have congressional to do today. So we will do a congressional warm-up also. Okay, ready? For the record, Mr. Speaker, it is ironic that at the very time when nations all over the world are collapsing economically and are being forced to move to free enterprise and free market principles and private property, the environmental lobby in this nation is forcing us to go in a very different and a destructive way. Increasingly today, the environmental movement is bringing great harm to the working men and women of the country and costing thousands and thousands of jobs. I believe what we need is some moderation. We need to realize that while we should always try to improve our environment, people have other needs too. We need to look before we leap. We need to stand up and tell these people that we can no longer afford to spend billions of dollars to meet some impossible standard that has almost no health benefit whatsoever. These are matters that I am very concerned about, particularly at a time when this nation is facing such difficulty. We need to protect our environment, but we need to do it in a way that does not destroy this nation economically and force us to become employees of the Far East and the companies from foreign nations. We need to tell the people that the best environmentalists are private property owners who most often take much better care of land than do government owners and at no cost to the taxpayers. We need to tell people that the worst polluters in the world are the government-controlled businesses around the world, while the most conservation-minded companies are those which operate under a free market system that forces them to act in an efficient manner. Above all, we need to tell the people that we want to make sure that this country remains free, so that Americans can succeed once again and not just survive. I want to commend the gentleman for what I think is one of the most outstanding comments on the environmental and economic situation in the country that I have heard in a long time. I wish that that could be heard by everyone in this country because I think it is shared by so many people. But it is not being made clear when the arguments that drive many of the movements and the regulations and the laws that come from this body destroy the economic initiatives for no real gain or purpose in the environment. The gentleman had an opportunity to speak in this very area where we presented an amendment to a bill that is drawn to take thousands of acres of national forest land out of timber production. It is drawn to set aside one area in a scenic area and one in a recreational area. In that designation, we tried to amend the bill to give the Secretary the right to continue to practice wise timber policy in those areas, and we were voted down by the committee. I want to say that I have an extremely high opinion of the gentleman from North Carolina and did not know that he was coming over here tonight. I certainly appreciate his participation in this special order because I do not think that many people realize how radical and strange some of these groups have become. They are very slowly but surely destroying the economy of the nation and hurting the working people. The gentleman has been in the forefront of the battle to preserve jobs for the working men and women of this country and to help this country remain strong in what is a very difficult time in the history of the nation. In my district, we have jobless rates that range between 20 and 30%. Our effort was to protect some of those remaining jobs. I want to tell the gentleman that I appreciate his remarks that he has just made. I supported the amendment, which we knew would be voted down in the committee because this Congress is the most liberal Congress we have ever had in the history of the nation. Some people think that is good. Some think it is bad. But there is certainly no dispute about that. This is the most liberal Congress we have ever had. We have a great many members in leadership positions in the Congress who do not believe in the free enterprise system and who do not believe in the concept of private property. So we are putting restrictions on land all over the country. We are taking over land at an unbelievable rate. It is just amazing to me that the federal government owns 97% of the land in Alaska at this time. It owns 83% of the land in Nevada. It owns just hundreds of millions of acres all over this country. The amount of land being taken over and tied up by the federal government all across this nation is growing by leaps and bounds. Every week we have bills in the committee to take over additional land. We have got a bill now that ties up some of the richest land in this country and ties up something like 8 or 9 million acres. Okay, so that was at 190. All right, we'll do a straight matter. Not yet. Okay. Straight matter. For the record, members of the jury, the judge has the ability to order you around. Look at what you've gone through since October 14. You were told when to come, when to go. Consequences would take place if once you were selected for the jury, if you just read the newspaper. If you just read the newspaper, or if you just watch the TV news, the things you do in your everyday life, or if you talk to a coworker who says, "What did you do yesterday?" "Well, I was in a trial, but I can't tell you about it." That's not normal, and you've been ordered and directed by the court not to do that. That has a hierarchical context to it. There's the judge who has the ability over you as jurors to tell you when to come and go. You've been told that you can't even think and deliberate about this case at this point. You are locked away for hours on end while we're out here arguing about something or other, and you have to think of other things to talk about or things to read and to bring about because you've been ordered not to deliberate on this case up to this point. So, ladies and gentlemen, if the concept is that Mr. Jones must have ordered in the hierarchy of this duo that the Commonwealth talks about, must have been the ordering party because he's older or bigger or more worldly, and they haven't given you any evidence of his worldliness except that he was in the military. That's all you know. That's all you know. Then there's, again, nothing that we can do or say about it because it's not in evidence. There's no evidence of what went on between Mr. Jones and Mr. Miller in that regard. Mr. Conway points to the Jones assassination. Well, one of the books is titled that. It's in the car or something like that. Then he points to, I can point to on the computer, the identification thing in the Windows XP. Well, it's not John Jones, that's Lee. So does that mean that he's in the position, higher position there, and you'll have an exhibit, that's the little jet fighter. You know he was interested in flight school, and the icon for the identification sign is on the little jet fighter. Well, so what does that mean? Who's more involved with the computer and things of that nature? When they were arrested, the computer was on the floor of the driver's seat of the car. Mr. Miller was in the front seat of the car, so he was closer to the computer. Does that mean anything? Of course it doesn't mean anything, but it means no more, no less than the type of suggestion the prosecutors make out of the pieces of evidence. You know, they've done a grand job of probably showing that this menacing car is involved, and they've done a great case of proving what Mr. Miller is attached to forensically, DNA, trace evidence, things of that nature. But There is a gap, and it's more than a gap. There is a canyon of evidence or lack of evidence about Mr. Jones. And again, the easy thing to do and the reasonable thing to do are to just fill in those gaps, but you can't. So let me go to the other exhibits Mr. Conway had. We just don't have the graphic ability to do it, and this stuff really is great. These things are just tremendous, and they're a big aid, but we do it with typewriters, and this blows up. And let me start with the Myers shooting, because that's where the evidence started. And I don't mean for you to read this. Again, this is as much for me just to go along. But you have the witnesses and then the evidence that was put in, and so I'm not going to go through that. I promise every one of those pictures and things in any stretch or every witness. But these are the witnesses as far as the witnesses at the Myers scene. That's the case that's charged here that Mr. Jones is charged with capital murder with. You have Mr. Myers pumping the gas. You have Jason, who was at the next pump over. He hears a noise, and then he sees Mr. Myers is in a terrible situation there, and he goes in and he calls for 911. Mr. Salazar is important because he says he doesn't really know where the noise came from, but he thinks it came from across the street. You know, this was on that gizmo, so it stays because they erased it. But let me show you what I recall. Is everybody okay? It was not his testimony that he's in this pump area here and that he heard the noise from here. It wasn't over here. The line was along this street by the median area. As far as the line is concerned, we're here on this cross street. I know that seemed kind of rambling, didn't it? Whew, that's how people talk. Okay, so that was 200. Okay, so let's do a jury charge. And this is also one of the legs of a past RPR test. So it would have been dictated at 200 words a minute for the RPR. Okay, you ready? For the record, members of the jury, it is now my obligation to instruct you on the rules of law that you must follow and apply in deciding this case. Soon you will go to the jury room and start your deliberations. You have dutifully heard all of the arguments and all of the evidence, and it is my job to charge you on the law, which you are to consider and which you will govern. It will be your duty to determine if the government has proven beyond a reasonable doubt the facts necessary to find the defendant guilty of the offense charged in the indictment. As jurors, you are the judges of the facts. It is your duty to determine from the evidence what actually happened in this case, but in deciding what the facts are and in arriving at your verdict, it is your sworn duty to follow the law, which I will define for you. You must be guided by these legal instructions as a whole. You must not disregard or give special attention to any one instruction, nor may you question the wisdom or correctness of any rule of law that I instruct you about. What I mean is that you must not follow your own notion or opinion as to what the law is or ought to be. The evidence in this case consists of the sworn testimony of the witnesses, no matter who may have called them, all exhibits received into evidence, no matter who may have produced them, all facts which may have been agreed to or stipulated, and all facts and events which may have been so noted by the court. When the lawyers on both sides stipulated or agreed as to the existence of a fact, you may accept the stipulation as evidence and regard that as proven. You are not required to do so, since you are the sole judges of the facts. Any of the testimony or the exhibits to which an objection was sustained by the court, and any testimony or exhibits that were stricken by the court must be disregarded, as must anything you may have seen or heard outside this room. You are to base your verdict only on the evidence in the case. You are not limited to the bald statements of the witnesses or to the bald assertions in the exhibits. In other words, you are not limited solely to what you saw and heard as the witnesses testified or as the exhibits were admitted. You are allowed to draw from the facts which you find have been proved such inferences as you feel are justified in the light of your common experience. In order for you to render a true verdict in accordance with the evidence and the law, all feelings of sympathy and prejudice must be laid aside. It is not your privilege to be vengeful or merciful. You must be objective, and your verdict must be based on the facts as you find them from the evidence and on the law given to you by the court. The punishment provided by law for the offense charged in the indictment is a matter exclusively within my province and must not be considered by you at all in coming to your verdict of whether the defendant is or is not guilty as charged. The defendant has entered a plea of not guilty to the charge, so the government must prove beyond a reasonable doubt each of the essential elements of the crime charged. I would like to discuss with you the concept of burden of proof. In this and every criminal case, the government has the burden of proving that a defendant is guilty beyond a reasonable doubt of each crime charged. The law presumes a defendant to be innocent of crime. Thus, the accused starts the trial with a clean slate. As I mentioned at the beginning of the case, I am entirely neutral about the outcome of the case. I do not want you to think that anything I have said, any instruction I have given you, any ruling I may have made on the evidence, or any statement I may have made either to counsel or to you implies that I have any position in this case at all, other than to give you fairly the law that you are required to apply and to rule fairly and impartially on the issues that have been submitted to you. I have absolutely no interest in how this case turns out, only the way it is done. As I've told you before, it is for you to find the facts of the case and to assess the credibility or the believability of each witness. If your memory of the testimony varies with any statements that were made by me or counsel, you have to be guided by your own memory and your recollection of the testimony. You determine the facts from all of the testimony that you have heard and the other evidence which has been received in the trial. Neither I nor anyone else may infringe on your responsibility as the sole judges of the facts. Of equal importance, you must accept the rules of law as I give them to you and apply those rules to the facts of the case. Now I am going to instruct you on your deliberations, what you are to do when you go to the jury room. First, the attitude and conduct of the jury at the start of the deliberations are things of importance. When you go to the jury room for your deliberations, they should proceed in an orderly way. The first order of business in the jury room will be to select one of you to be foreperson. You are free to pick any one of you to act in that capacity. The foreperson will preside over your deliberations and will speak for you here in court if that should be necessary. Okay. So I started that at 200, went all the way up to 225, and then back down until we got back to 200. The last minute was at 200. Okay? All right. Are you warmed up? Okay, let's do takes. Let's see.